Okay, we'll go ahead and get started. Welcome everyone to Boulder County Senior Lawn Day 2020. We are so happy to have you here, and we're going to be talking about Medicaid and long-term care today. But we have a few announcements before we get to today's topic. So first of all, due to our new virtual format, some things are a bit different. We already had our first question, and I'm so excited I get to answer it right away. Today's webinar is being recorded. The video will be available later on the Boulder County Senior Law Day website. Right now we have our first 3 webinars up there. We've developed a YouTube channel, but the link to the YouTube channel is on our website. Our website is in the chat, a link to it. It's bouldercountyseniorlawday.org. And we are so happy to have you here. If you have noticed, the host has muted all of our attendees. Please leave yourself on mute until the speaker invites you to unmute yourself, which may not happen. We have a few ways for people to share questions, though. We have a question and answer box that some of you have already been able to access. So please feel free to type in your questions as they occur to you. It's up to the speaker whether he wants to take questions and provide answers in the middle of the talk or at the end. Sometimes it makes more sense to do that in the end. We have one more week after today of webinars. We're really excited about next week. Tuesday is going to be Aaron Eastvet with Colorado Legal Services Health and Elder Law Unit talking about Social Security. And Thursday will be our estate planning webinar with Kurt Hofgaard, who's an attorney here in Boulder County and our president-elect of the Boulder County Bar Association. Following our estate planning session, we will have a bonus session on train wrecks and estate planning. So feel free to sign on for that separately. And again, you can access all of these at our website, bouldercountyseniorlawday.org. Due to this year's virtual format, things are a little different, and we are not able to offer our usual Ask a Lawyer program that we have in person. However, our platinum level sponsor, the Boulder County Bar Association, provides a free legal clinic during this time, and they got that running for a couple of months, so it goes so smoothly when people sign up for it. Callers are paired with attorneys to provide free legal consults on a variety of issues. To sign up for that, go ahead and call the Boulder County Bar Association at 303-440-4758, or you can go to their website to sign up on an online form, boulder-bar.org, and that link is also in the chat. Our Senior Law Day Handbooks, for those of you who have attended the event, they are such a great resource that you get to pick up at the end of the day. Right now, they are available online at seniorlawhandbook.org. And that link is also in the chat. And if you need a physical copy for some reason, please contact Erica Corson at the Boulder County Area Agency on Aging, 303-441-1170. Thank you so much. And finally, thank you to our sponsors. This event would not be possible without them in a digital or real life fashion. So we are very, very grateful for their help. And with that, I would like to introduce our speaker, John Estes of Kapsak Law. John is an attorney at Kapsak Law Firm in Longmont, Colorado, where his practice focuses on estate planning, estate administration, and elder law, including Medicaid planning and planning for long-term care needs. Prior to joining the Kapsak Law Firm, John worked for Colorado's state Medicaid department, drafting long-term care regulations. John is also a proud member of the Niwot Rotary. In his free time, he enjoys training for and racing triathlons. So John is not only very impressive in his knowledge of Medicaid, but in his ability to engage in triathlons, which I am very impressed with. I lack that skills. So we are really excited to have John speak today. I will, just on a personal note, say Medicaid is so complicated and so difficult, and there are very few, even attorneys, who fully understand it. So we are so lucky that John is giving his time to share this with us, because he is one of the few handful of attorneys who really gets this to his core. So many thanks, and I'll turn it over to you, John.
All right, thank you very much, Brett. And I'm going to try to share my PowerPoint presentation on the screen. Let's see if that, all right, it's working, good. Well, thank you all so much for taking your afternoon today to hear about Medicaid, and specifically this presentation is going to be about long-term Medicaid, basic eligibility, and common things that you need to be aware of if this is something that you or a family member are considering or are looking at. So first, at the very basics, what is Medicaid? And it is a hybrid program that has federal requirements as well as state requirements. So each state's Medicaid is different. It's not a universal program run by the federal level, but rather the federal government sets certain standards that every state has to comply with and provides some of the funding. And then the rest of the funding comes from the states, and they can have their own individual rules and regulations relating to their program. So everything that I talk about today is specific to Colorado Medicaid. It won't apply necessarily to any situations with family members who are out of state. The second thing is that it is a safety net program, which means it does have eligibility requirements that are tied to an individual's financial status and ability to pay. It's not something that is available for everybody, but only for those who truly need it. It's often confused with MEDICARE, and they do serve different populations. So MEDICARE is an entitlement. You pay into it and you're entitled to it once you reach 65 years old or once you have a qualifying disability. There are large differences in what these two programs cover. So despite MEDICARE being health insurance for the elderly, it actually does not cover a lot of the common expenses that the elderly population incurs, especially when it comes to long-term care services in nursing facilities, rehab facilities, or assisted living. Medicare covers some, but only a very limited amount. So Medicaid is the primary payer for those long-term care services. As I mentioned, Medicaid is run by the different states. Medicare is a federal program. Everyone in the country is running under the same program. And again, they have differences in what they cover. So why are we talking about Medicaid, and why is it important, especially as we're talking about an aging population here in Colorado? And one of the main reasons is that Medicaid does cover a large population, a large portion of Colorado's population. This information, this data is a year old at this point, but as of 2019, Medicaid was the primary health insurance provider for roughly 1/4 of Coloradans. I haven't seen any information in the past several months, but I imagine that this has actually gone up, that it now covers or is the primary source of insurance for more than 1/4 of Colorado. It accounts for $9 billion plus annually from the state budget, and the Medicaid nursing facility expense is the single largest line item in Colorado's state budget. And this information is covering two different types of Medicaid that I just want to make a distinction, because there are two different types of Medicaid. Most of this presentation is going to be long-term care Medicaid, Medicaid that covers long-term services and supports, nursing facility, in-home care, and assisted living facility. There's also MAGI Medicaid, which is specifically tied to an individual or a household's income level. I'm not going to be talking much about that, but you might know somebody who is on MAGI Medicaid, and what their program requirements are won't necessarily track what we are talking about today. All right, so long-term care Medicaid and long-term care is all of the services necessary to care for individuals with extensive assistance needs, individuals who need assistance with activities of daily living. Those are defined as bathing, cooking, cleaning, dressing, ambulating, so walking around the house, getting up out of bed. All of those are activities of daily living. The need for help with this could come from advanced age. It could come from disabilities in younger individuals. So that's the population that this program is designed to serve. And the cost of long-term care is exorbitant, depending on an individual's needs. It could be as simple as having someone come into the house twice a day, once to get you out of bed, once to put you back into bed at the end of the day, maybe to cook a couple meals in the middle, and in that case, it might not be an excessive burden financially. On the other end of the spectrum, individuals who need help constantly throughout the day, they are in a nursing facility, or they need 24-hour care in the home. This cost can be in excess of $10,000 per month here in Boulder County, $9,000 or more in the Denver metro area. So how do we pay for that? If you can get it, long-term care insurance is a viable option. It's not part of most health insurance plans, but can be sold as a separate rider either onto health insurance or sometimes onto a life insurance policy. It has some benefits. So one of the benefits of long-term care insurance is that if you get a policy, say, that pays out up to $250,000, and it is a Medicaid qualified long-term care insurance policy, then when it comes time for you to apply for Medicaid to cover the rest of your long-term care, you can have additional assets on top of the starting asset cap for long-term care Medicaid, up to that $250,000 amount. One alternative that many people use is private pay. So just taking out a reverse mortgage on the house, or using savings retirement accounts to pay the monthly costs of the care that's being received. And then public pay is the primary payer for long-term care here in Colorado, and that's the combination of Medicare and Medicaid, and to a lesser extent, some benefits through Social Security, such as I'm blanking on it, aid and attendance through the Veterans Affairs, and using SSI or SSDI to help cover some of those costs. All right, so what's required? What do you need in order to be eligible to receive long-term care Medicaid? And the first requirement is that you do need to be a citizen or a legal alien, legal permanent resident, and you do have to be a resident of Colorado. So since it's state specific, if you are applying for Medicaid, you are applying in the state that you are a resident of. If you have residence in multiple states and you move around, it could be possible that you financially don't meet the requirements for Medicaid, but at the very least, you would be applying in one state and then having to transfer your eligibility from one state to the other when you move. You must meet the functional needs threshold, and that's a medical test for whether you need the level of care that would dictate needing long-term care. And that's pretty simple. You need assistance with at least one activity of daily living. All right. The next are the resource limitations. So this is where we really start to look at what you need to know, what you need to plan for if you or a family member is looking at long-term care Medicaid as a potential option for meeting your long-term care needs. The first of the resource, I've got these, all right. So I've got my slides in backup order. I apologize for that. The first test is the income limit. So we'll address that first. And that's your monthly income cannot exceed $2,349 per month in 2020. This income number does get a cost of living adjustment every year. So in last year, it was about $2,311. It went up by $38 in 2020. As we talked about, the average cost of long-term care in Boulder County is in excess of $9,000. I don't have the official number that Medicaid uses for 2020, but it was near $9,000 back in 2018. And so for someone who has income over the $2,349 per month, but still has nowhere near enough income coming in every month to pay for long-term care in Boulder County, they can use an income trust, also known as a Miller Trust or a Utah Gap Trust, to collect any excess income, apply that towards the cost of care, and then have Medicaid pick up the difference. And that can be used up to the average nursing facility cost in the area in which you live. And it's not strictly divided by county, it's divided by Medicaid's areas of care. As mentioned, Boulder's is in excess of $9,000 right now, as is Denver's. The stricter limit test is the resource limit. So when you apply for long-term care Medicaid, you can only have countable resources up to $2,000 for an individual and $3,000 for a couple if both individuals are applying for long-term care Medicaid. These numbers do not get a cost of living adjustment. These have been the numbers that have been in place since Medicaid first became a program, or long-term care Medicaid first became a program. So that's not that much money. As you all know, it's less than 1 month's of permissible income. There are resources that are exempt from this resource limit, and there are spousal protections that do apply, and we'll talk about those. But when you are applying for long-term care Medicaid, you are certifying to Colorado that you are impoverished, that you have exhausted all opportunities and all options for private paying, and that you have no more personal assets that can be used to cover your own care needs. This is where it's a safety net program. You are saying to the state and to the federal government, I have done everything that's within my means to meet my health needs, and now I need assistance because I can do no more. So some of the primary exempt resources that you can have that do not count towards that $2,000 amount are a house, and that's with an equity value up to $595,000. You can have one exempt vehicle, no limit on what the value of that vehicle can be. Second vehicles do count towards that $2,000 resource limit. You can have a life insurance policy where the face value of the policy does not exceed $1,500. If the face value does exceed $1,500, then the cash value of that policy does count towards that $2,000 resource limit. You can have an irrevocable burial insurance policy or an irrevocable burial plan that does not count towards the exempt, towards the resource allowance. And you can have personal property that does not have excessive, sellable value. So if it's an antique that's investment grade, or jewelry that's investment grade, that does count towards the resource allowance. However, if it's clothing, furniture, technology, computers, TVs, family jewelry that does not have a large resale value, those types of things are exempt. They don't count towards that $2,000 limit. All right, now on to how we protect the spouse. So the first step is, if one of the spouses is applying for Medicaid, they have to have resources under $2,000. The non-applicant spouse, which is known as the community spouse, can have an additional amount called the community spouse resource allowance, an additional $128,640 in countable resources, and still have the applicant spouse be eligible. This number does go up every year for a cost of living adjustment. This year it went up about $2,000. And importantly, this number is a snapshot in time. So what this means is the amount that the community spouse can have in as a exempted resource is only looked at as of the date that the applicant spouse is applying and determined eligible for Medicaid. If the community spouse continues to receive income that pushes him or her over this $128,000 amount after the applicant spouse has been approved for Medicaid, that increase in the community spouse's equity will have no impact on the applicant spouse's continued eligibility for Medicaid. All right. There's also protection for the community spouse for income. So let me back up for a second and clarify. When you apply for Medicaid, for long-term care Medicaid, the state looks at both the applicant's resources as well as the spouse's resources. And we've just talked about that additional amount that the spouse can have. The state only looks at income for the applicant spouse. So it doesn't matter how much income the community spouse has. Medicaid is only looking at the income of the individual who is actually applying for benefits. If the community spouse is the lower earner of the two, so let's take the hypothetical where the wife is applying for Medicaid and she has retirement income coming in the form of a pension of $6,000 a month, and the husband is the community spouse, but he's only got Social Security of $1,000 per month, then he can apply for a minimum monthly maintenance needs allowance, MMMNA. Terrible acronym to say, but it just doesn't roll off the tongue easily. But what this allows him to do is in the application say, I want to take some of my wife's income and have that go to me so that I can be brought up to the minimum amount I need to continue to live in the community. And that amount in 2020 is a range from $2,155 per month to $3,216 per month, depending on certain factors. I'm not going to go into those factors. That's beyond the scope of this presentation. But it's good to know that this, if you're applying and the high earning spouse is the one seeking Medicaid, this protection is available for the community spouse to bring his or her monthly income up to the level they need to stay in the community, to stay independent. As I just mentioned, all resources in applying are joint. Doesn't matter who holds the title. So even if title to the house is held in the non-applicant spouse, Medicaid is going to look at both, look at that asset in determining eligibility. But for income, the state only looks at the applicant's income. Okay, so now let's talk about some of the common pitfalls. We've talked about the basic eligibility requirements. And to reiterate, you have to have a need assistance with some activity of daily living. You must meet that medical needs test. You have to be a citizen, a legal permanent resident, or a legal alien, and you need to be a resident of Colorado. You have to have income below $2,349 per month, although there is some flexibility if you're over that by using an income trust. And you have to have countable assets below $2,000 or $3,000 for a couple. Now let's talk about, in planning or in addressing this, what are some of the pitfalls that people run into? The first and the biggest one is the transfer without fair consideration. So one of the presumptions that Medicaid is looking at, that I touched on very briefly, is that Medicaid is there to help you when you have done everything you can and you can't help yourself anymore. One of the issues that Medicaid wants to avoid is people giving away all of their assets to children, to friends, to family, whatever, specifically so that they can get this long-term care Medicaid benefit without having to spend their own money on their care first. So what Medicaid has done to combat this is imposed a 5-year look back. And what that means is from the date that you are eligible to apply for Medicaid and actually apply, Medicaid looks back 5 years on all of your financial transactions to see if you did any impermissible transferring of property or gifting of property without receiving something for fair consideration of fair value in exchange for those gifts. The presumption, if you've made one of those transfers, is that you did it with the intention of becoming eligible for Medicaid. And if that is found to be the case, then Medicaid imposes a penalty period, the duration of which is based on the value of those transfers, the value of those gifts. And there's a little bit of a calculation there. To make the numbers easy, let's assume that the average cost of Medicaid, 1 month of long-term care in Boulder County is $10,000, and you gifted $100,000 prior to applying for Medicaid, then the penalty period for that you're going to be ineligible for Medicaid is 10 months. It's the value of the gift divided by the average monthly cost of care in your area. All right. One other important part is that this penalty period begins on the date you would otherwise be eligible for Medicaid. So it's not dating back to the date of the gift. It's dating back to the date that you have now spent down to $2,000 in countable resources. You meet the income requirements and you have applied for long-term care. All right, so what do some of these gifts look like? What are some common mistakes that I see that people make? One is transferring property into an irrevocable trust or a revocable trust. Doesn't matter which. If you're transferring property into a revocable trust that you still control, Medicaid considers all of the assets of the trust to be your assets. So if they would have been exempt assets in just your name, but you've now transferred them into a trust, good example is a house. That house now loses its exempt status. It is now a countable resource. You're no longer eligible. If you transfer assets into an irrevocable trust, then the entire value of assets transferred into that irrevocable trust counts as a transfer without fair consideration, and you may get hit with that penalty period. There's transfers to family and friends, and we're really not so much concerned with small gifts for birthdays or holidays, but transfers of vehicles or adding a family member onto a bank account as a co-owner, joint owner with right of survivorship, or even as a pay-on-death beneficiary. Those types of transactions can cause Medicaid to look at that as this was an impermissible gift. We're going to impose a penalty based on the value of that asset that you transferred. A big one for a lot of families, many times before nursing facilities get involved, one or more family members will engage in providing care for their parents, for siblings, and they do this so that they can best meet the care needs. It's never done with bad intention. And at some point they might think, well, if I'm providing all this care and all this money is going to end up going to the state to pay for the care anyway, or going to go to the nursing facility, then I should get paid for the time that I spent giving that care. This is a really important area to talk with an attorney or talk with someone who's well-versed in Medicaid before you pay yourself, because Medicaid's rules are very strict that you have to have a contract in place for what services are going to be provided, what the rate of pay is going to be, how documentation for what services are actually provided is kept, and this contract must be put in place prior to any of the care that's being given for which you want payment. So if you decide after providing care for 6 months, you know, I really should be compensated for my time, yes, you probably should, but you need to put that contract in place and only pay for what care you provide after the date of the contract, and not backdating that to that 6 months ago when you started providing care. Otherwise, all of those payments will be a transfer without consideration for Medicaid. And then I talked about this under transfers to family and friends, adding family members on as joint owners on property, either real or personal property, cash accounts such as bank accounts, checking, any of that will be counted as a transfer without fair consideration. All right, so to avoid these penalties, ensure that there is a contract in place for all caregiving provided by a family member. Ensure that this contract has been reviewed by an attorney or a Medicaid planner who's familiar with Medicaid's regulations for that. It doesn't help a lot to have a contract that doesn't meet Medicaid's requirements and then get hit with that penalty. If you are planning on making gifts and you have the financial wherewithal to do this, you've got several years worth of private pay set aside, make all those gifts 5 years before you're going to need Medicaid. So you can sit down and look at it and say, if I needed long-term care tomorrow and I need to private pay for 5 years at $10,000 a month, that means that I need to have roughly $600,000 set aside, and I can gift away the rest. Using ballpark figures here, don't take these numbers as gospel. But if that's something that is financially available to you, that's a course that you could take where you start making gifts now and say, I know I've got enough to take care of me up until the date that I need to finally spend it down and apply for Medicaid. Be careful with this, because if you make it 4 years and 364 days and then all of a sudden need to apply for Medicaid on that 364th day in the 4th year, all of those gifts that you made almost 5 years ago do get brought back into that 5-year look back and get counted as towards any potential penalty period. So if you're going to use this strategy, it is imperative that you be able to make it 5 years before actually applying. Keep all documentation. This is good advice in general for your financial health, but especially if Medicaid is on the horizon. Keep receipts of what things are spent for. Keep track of all check copies. Keep your bank account statements. Make sure that you can access those going back at least 5 years, hopefully longer. If there are any transactions between family members, put them in writing. A lot of times families don't think that's necessary, but if Medicaid is at all a possibility, make sure that everything has a document trail, a paper trail that you can rely on. All right. Once you're on Medicaid, Medicaid does keep track of all of the money that they spend on you, on your care. And once you die, Medicaid can file a claim against your estate for the value of all services that they provided. So in this way, Medicaid is still living up to that safety net program status. It's providing you your medical care during your lifetime, and if there's anything in your estate when you die, Medicaid can seek to recover from your estate the value of services that it provided after your death. And this is primarily from those exempt assets that we talked about earlier. So you've got the house. You apply for Medicaid and your house has $500,000 in equity. Medicaid says, great, we will pick up the tab for your medical bills until you die. But once you die, we're going to file a claim, and if we've spent $300,000 on your care, we're going to get that $300,000 out of the value of your house, which we allowed you to keep when you applied. There are some instances, they are quite rare, but they do happen, where Medicaid can place a lien on a Medicaid recipient's house while the recipient is still alive. This primarily occurs in instances where the Medicaid recipient is on long-term care Medicaid receiving services in a facility, and it is now well documented that the person has no chance of returning to their home. In that case, Medicaid may seek to protect their interests by putting a lien on the property. Again, it doesn't happen often, but it is a possibility. All right. So for how do we plan for Medicaid? How do we get you on? If we're working with a married couple and only one spouse needs Medicaid, then we can do some things to ensure that the assets of the couple are there to take care of the community spouse. And one of the most common tools is a Medicaid compliant annuity. And what this means is we're going to go back and look at how Medicaid looks at the assets of a couple jointly, but the income of couples separately. So with a Medicaid compliant annuity, we can take a set dollar figure, let's say $200,000, and purchase an annuity that gets approved by Medicaid and is set up to pay to the community spouse. When it's time to apply for Medicaid, the couple begins taking distributions from that annuity, and this is it's set in stone that once you start taking annuities, you can't change it. It's an irrevocable annuity. You can't revoke the annuity. You can't get the initial cash value back. You're now locked into taking those monthly payments. But what that has done from a Medicaid perspective is it has changed a countable resource into an income stream for the non-applicant spouse. So we get the applicant spouse onto Medicaid. The community spouse can now receive that income stream from the annuity. It does not count as income towards the applicant spouse, and we're protecting the long-term financial interests of the community spouse. There are limitations on who the beneficiaries of that annuity can be in order for it to still qualify as a Medicaid compliant annuity, but this is one way to ensure that the non-Medicaid spouse can have income coming in to meet his or her needs. Another tool is using special needs trust during your lifetime for family members who Medicaid either is currently being received or is a possibility to be received. All right, so planning for loved ones. So if you've got a child or a parent who is on long-term care Medicaid, then in your will, in your estate planning documents, don't make direct bequests to them. Don't leave money or property to them outright and free of trust. Instead, either omit them entirely so that they're not having assets come in that jeopardize their Medicaid needs, or you can use a third-party special needs trust where the assets are held in trust, funded by someone other than the Medicaid recipient. And these trusts can be used to meet the individual's needs that Medicaid doesn't cover. So Medicaid covers a lot of healthcare needs, but it doesn't cover everything. It has limited dental coverage, limited vision and hearing coverage. It provides relatively little access to funds for clothing, for hair care, for technological needs, if they need a new phone, if they need a new computer so that they can interact with children, grandchildren, etc. These trusts can be used to meet those needs. And they're drafted, they are technical documents. Do not do it yourself. These you need to talk with a competent attorney who does special needs planning to put together so that these trusts can be available for the benefit of an individual who needs Medicaid, but in a way that they don't actually cause the individual to lose Medicaid benefits. All right. Finally, asset protection. This is one of the #1 questions that I get asked by clients who are all of a sudden looking at Medicaid as a possibility. And with the regulations and the rules as they are currently set up, there's pretty limited opportunities for asset protection and getting onto Medicaid. If we've got enough assets that we can plan 5 years out and start gifting now, knowing that we have funds to get us through 5 years of care, that is one option, and we can do that. You can also use a combination of irrevocable trusts and annuities to pre-plan for a penalty period and intentionally trigger that penalty period. But it's not without risk, and it's not without trade-off. So one of the #1 trade-offs that you clients have to understand when they come in is, if we want to protect assets from being used on your health care and get onto Medicaid, there's always a risk that you could get hit with a penalty period, and we do our best to plan around that, but it needs to be done perfectly. And you're going to be giving up control of your property. There's no way to both protect your assets and keep complete control. And this is true for asset protection generally, even in the non-Medicaid context. If asset protection is something that is a priority to you, and leaving an inheritance is something that is a priority to you, the trade-off is that you're going to be giving up direct control to meet that end. And that's everything that I have for my presentation. So I believe I've got about 15 minutes left when I'd like to open it up for any questions, any comments, anything specifically that I didn't cover that you would like to talk about, or specific situations. So Brett, I'm going to turn my screen sharing off and turn it over to you to open it up to any of our guests who have questions for me at this time.
Yeah, so we do have a number of questions already in the chat or in the Q&A. So the first question is, with exempt life insurance policy, if someone has 2 separate life insurance policies with cash values each being below that $1,500, will they both count as an asset since the total of the policies is over that $1,500?
That is a good question, and it's whether they are countable is actually dependent on whether the face value of those life insurance policies is over $1,500. they would be looked at separately for Medicaid. So it's possible that one of those policies would have a face value over $1,500. I can almost guarantee the one that has the cash value of $1,475 has a face value over $1,500, but the $300 one may not. So that's actually a distinction where we're looking at the face value versus the cash out value, which are not always the same thing. But each life insurance policy is looked at separately, and whether it's determined in the countable resource amount depends on whether the face value of that specific policy is over $1,500.
Great. Our next question involves residency. What if you live in Colorado but spend a few months abroad to avoid the winter?
Okay, and I want to make one clarification point here, which is that by abroad, if we're talking about another state, another U.S. jurisdiction, then what you would need to, you are eligible for the months that you live in Colorado. For the months that you live in another state, you would need to have your Medicaid eligibility transferred to that state, and there is a process for that. It can take a delay because the different eligibility standards are different state to state. If we're talking about abroad being a separate country, then you're going to have your Medicaid terminated when you go to that country, and you're going to have to go through the process to get it reinstated once you return to Colorado. So transferring from state to state is a more cumbersome than I personally think it should be processed, but is not too overly difficult. But if you go to a different country and come back, while you're in that separate country, you no longer have Medicaid, and when you come back, you'll have to get it reinstated.
And I have a quick follow-up to that. What about just for a quick vacation? Like if you were to go to Europe for a week?
Your Medicaid eligibility does not change in that case. It is tied to your residency. And so we're really looking at issues where if it's going to be several months and you're now a resident of that other state. But as a practical matter, even if you're in another state or if you're in Europe, your medical coverage under Medicaid is state specific. You have to use Medicaid approved providers. So your eligibility will still be intact while you're on vacation, but your practical ability to get access to healthcare under that Medicaid insurance is going to be, I'm pretty confident in saying, non-existent. You're not going to be able to get any healthcare coverage while you're on that vacation until you get back to the state in which you're receiving Medicaid, where you can go to a Medicaid approved provider.
Wow, thank you. Next up, we are running into more and more instances of multi-generational households where children live in or co-own homes with a parent who ends up needing long-term care Medicaid, or share bank accounts that both the child and parent contribute to. Any advice on these instances?
Yes. So in the case of families where you've already got a joint ownership on the house, you want to have readily accessible all of the information about when that purchase took place, because if it's outside of 5 years from the time that the parents apply for Medicaid, it's not going to cause any transfer without consideration issues. It is going to cause some issues with respect to how that house is counted as a resource for Medicaid, because the children are going to be deemed to have some value of the house, and the parents are going to be deemed to have some other value. And there's actuarial tables based on the life expectancy of the adult parent and of the adult child as to how that's going to be proportioned. But usually in those cases, Medicaid is going to look at it and say, this house is not exempt, or it's only exempt up to the value that the parents have, because Medicaid's concern there is we're not going to be able to go after it in estate recovery if it transfers by operation of law by joint tenancy. there are exceptions to estate recovery also for those families where if you're living in the same house and you are providing care to your parents while living in that house, and then they die and you get that house as an adult child or as a spouse, then that's not going to be eligible. It's going to be one of the exemptions to estate recovery. And I didn't talk about the exemptions because it was too much to get into in the short time that we have. But that is a possibility. Same thing with bank accounts. If you were added onto it, have ready the date that you were added onto it so that you don't get into any questions about transfers without consideration. But also be ready that Medicaid is going to look at this and say everything in that joint account is a resource of the parent that's applying for Medicaid. And so if that's not your intention, have documentation as to who funded the account with how much, because otherwise Medicaid is going to say the entire account is accountable resource. I'm not a fan of joint bank accounts between parents and children to begin with. I don't like that commingling. So if the objective for that joint account was just ease of access, that the child can help out with the parents' bills, then get a durable power of attorney in place and have the child acting on that account as an agent and not as a co-owner. Because for this very reason and for other reasons, I do think these joint accounts are susceptible to at best ambiguity about whose funds they are, because legally they belong to both, and at worst they're a possibility for exploitation. So if the sole purpose of having this joint account is ease of access and having the children able to help out, get it back into the parent's name and have a durable power of attorney where the child can act on it as agent.
Great. And then next up, we have a question about income. Is the income amount looked at separately, even if the couple files taxes jointly?
That's a great question. I think a lot of the confusion surrounding Medicaid is Medicaid's rules and IRS regulations oftentimes are not in sync because Medicaid treats income differently than the IRS does. So the answer to this is yes. Income for Medicaid is looked at separately because it's how we're looking at it specific for applying for Medicaid, even though at the federal level for tax purposes, your income is going to be considered joint.
All right, next up, what do you recommend for those who need help navigating all of this with extremely limited resources?
That's a great question. There are, so I'm going to throw some of this to Brett Landis at Boulder County Legal Services is a great starting point where they may be able to help out with some of it. There are non-attorneys who are well-versed in Medicaid applications and Medicaid eligibility, where working through this system, they can do it at a less expensive rate than an attorney's hourly rate. I'm blanking on the name of a couple of them off the top of my head, but I can follow up with Brett on who some of those are. I know in Longmont, it's been curtailed somewhat due to COVID, but there are quarterly, I think they're quarterly legal clinics that are put on at the senior center, and I think at the moment they're just handing out phone numbers for attorneys who are offering 15-minute consultations free of cost where we can help kind of talk you through some of the basics. I will try and get that information out as well. I know I am one of the attorneys that is on call for that, so until we can begin meeting in person again, there are clinics that are being put on, at least in Longmont, and Boulder I know has their own as well, where you can get 15 minutes to talk with an attorney about Medicaid, kind of get some of the basics straightened out. And then if you're on extremely limited resources, good chance that this is exactly both the presentation and the program that you're looking at. And so you can pick up the information for applying for Medicaid from the website and submit it. And you're likely going to be eligible with less resources. You're probably not going to hit as many of the truly tricky situations that come up, but it's still possible. And if that happens, get in touch with Brett at Boulder County Legal Services or attend one of the clinics.
All right, what about veterans benefits for long-term care?
That's a great question. I do very little with veterans benefits. I know aid and attendance is available for those who need it, and there is some overlap in services. The benefit to veterans services is they can often help either bridge a penalty period, where if you've had a transfer without consideration, or if you're doing the private pay and you're trying to spend down and you want that to last as long as possible, then programs such as aid and attendance can help get you services in the house until you're eligible for long-term care Medicaid. As far as specifics, talk to someone who is well-versed in veterans benefits, and I know just enough to be dangerous on that topic.
Okay, our next one is, please repeat the last sentence of the presentation regarding the importance of leaving a house as inheritance.
Okay, I'm not sure exactly what this is relating to. One of the things I was talking about is estate recovery, which is that Medicaid can go back after the value of a house for any care that they've provided. And there's not a whole lot you can do about that. There are exemptions to that, where if you leave the house as an inheritance to a spouse, that is exempt from estate recovery. There's also some exemptions if the beneficiary of the house is an individual who meets Medicaid's definition of disabled and would be otherwise eligible to receive Medicaid or other government programs, and by receiving this inheritance they don't. That gets it out of estate recovery. Or if you have been living in the house providing care that has kept the Medicaid recipient from needing long-term care for at least 2 years, there's an exemption there as well. But generally, it's important to keep the house, and this is an area to talk with an experienced advisor about, because there are pitfalls relating to houses. So without knowing the specific situation, I will leave it at that. Talk to an attorney, talk to a Medicaid counselor, someone who's well-versed in it, to make sure that you're not somehow jeopardizing the applicant's eligibility.
Yeah, and you may have already just covered this. Is Medicaid going to ask for a sum of the house after the senior's death? So I guess maybe how much will they ask for might be another way.
So what Medicaid is going to do is they are going to submit a claim as part of the individual's probate estate, and that claim is going to be supported by an invoice for every single penny that Medicaid has spent on the individual's care. Now, their claim is limited to the estate, so family members have no personal liability to pay that claim. But Medicaid can seek reimbursement up to the total amount that they paid in care for the individual. So if they've spent $500,000 on care and the house is worth $350,000, they're going to get the entire value of the house.
Great. So next up, if an elder person placed in a facility has several homes, is it a necessity to sell their homes first, spend that down, then file for Medicaid? And do guardians get paid out of the estate? Does Medicaid know how much the guardians are making?
Okay, so that is a great question. The first answer is yes. If you have several homes, only your primary residence is exempt. The rest of the houses are countable for Medicaid. So in order to even be getting onto Medicaid, you've got to sell those, spend down, get under that $2,000 threshold. As far as guardians, so I do guardianship and conservatorship work as well. Guardians can get paid out of the estate. How much they get paid is dependent on the court order that appoints them. Oftentimes that may be listed as a reasonable fee, so it may not be set in stone. But yes, they do get paid. Medicaid does not know how much they are making, but can request that information if they believe that the guardian is making too much, that the amount is not reasonable, is not consistent with the amounts that that are common for professionals in the area.
Great. We're winding down here. Is it permissible to set aside funds for funeral expenses? And if so, how much?
So yes, irrevocable funeral plans, irrevocable burial policies are exempt from that $2,000 amount. There's no cap on how much you can fund those with. The one requirement is that they be irrevocable, meaning once you've put the money in, the only thing it can be used for is funeral expenses, and it's set in stone, so that it's not going to be, we're funding this with 500,000 and 30,000 gets used on funeral expenses and the rest can get paid to the family. There are restrictions on how those can be set up. Every funeral home here in Longmont that I've worked with has these types of plans that are Medicaid approved, that are irrevocable, and so work with them to set one up. And it can either be, we've got a set funeral trust that's set up through the funeral home that's set in place, or it's a irrevocable policy that's in place. But there's no limit on how much that can be funded with. It just has to all go towards funeral expenses. It's not a way that we can set aside and store a hidden inheritance.
All right. And I think this one is actually just a resource that someone very kindly.
Veronica is amazing. If you are in Longmont, Veronica and Susan Spalding run the clinic. They run a number of programs for older adults. They are an outstanding resource, and the number that's up there, and I'll say it out loud for those who can't see it, 303-651-8411 is Longmont's resource specialist. Give them a call. They're awesome, and if it's beyond what they can do, Veronica has my number and puts me in touch with clients as well. So.
Well, fantastic. What a great note to end on. I'm just going to share our sponsors again, but I want to thank you so much, John, for taking the time. I know this has been a really, really important topic, and getting all of these questions answered is definitely showing how much interest there is in this. So thank you so much.
Before I go, I want to put in a huge thank you to Brett Landis and the Senior Law Committee for putting these on. I know I have been involved with senior law in Boulder for several years, and I was non-existent at all on the planning committee for this year, but all of these presentations are due to Brett's hard work and the hard work of everyone she's been on her team to get these presentations in place. It's been a hard year with the pandemic, but I think the information is still really good information. So I want to give a huge thank you to Brett and everyone involved in putting this on, and hopefully the rest of the presentations continue to go well. But thank you for having me. Thank you for joining. And again, Brett, thank you. Well,
thank you. And yeah, just so everyone gets credit, my co-chair, Margie Greek, has been amazing. Her fiduciary services, Pearl Fiduciary, is one of our sponsors. Kurt Hofgaard of Hofgaard and Associates, Pete Rogers, who is a private practice attorney, and Erica Corson at Area Agency on Aging. And then, of course, Laura and Kyle's help at the Boulder Bar Association. So this has been wonderful. Thank you so much. And on that note, we'll let everyone's log off as they need to. Thank you so much. This was great.
All right, thank you.